Good morning. I'm Gary DeWaal, and this is Bridging the Week for February 8th to 12th, and today is February 16th, 2016. International developments dominated regulatory news involving exchange-traded derivatives last week. The European Commission and the Commodity Futures Trading Commission finally inked a deal to recognize clearinghouses under each other's oversight as subject to equivalent regulation, while the European Commission formally proposed to delay for 1 year the rollout of MiFID II. In addition, the head of the investment office that housed the so-called London whale agreed to settle charges with the Financial Conduct Authority in the United Kingdom for his alleged lack of forthrightness with the regulator in early 2012. Finally, MF Global Inc., whose sudden collapse rocked the futures industry in fall 2011, effectively shut its doors for good when the U.S. federal judge overseeing its liquidation formally closed the firm's estate and ended its liquidation proceeding. We've got a lot to cover on this first day of a shortened work week after President's Day weekend in the United States, so let's get started. The Securities and Exchange Commission adopted final rules that will require non-U.S. persons to include in a calculation necessary to assess whether they must be registered as a security-based swap dealer all dealing activity involving security-based swaps with other non-U.S. persons, that is, quote, arranged, negotiated, or executed by that person's personnel who are located in a U.S. branch or office, or by its agent's personnel who are located in a U.S. branch or office, end of quote. The requirement would apply in connection with security-based swaps executed over the counter, as well as to security-based swaps executed anonymously and cleared. The SEC's requirement is similar to a requirement of the Commodity Futures Trading Commission articulated in a staff advisory in November 2013. However, the effective date of the CFTC's requirement has been delayed until the earlier of September 30th this year, or the effective date of any CFTC action addressing related matters. The compliance date of the SEC's new requirement is the later 12 months after publication of the new rule in the Federal Register, or 2 months prior to the last compliance date for a number of other requirements the SEC will impose on security-based swap dealers and major security-based swap participants known as the Security-Based Swaps Entity Counting Date. That's a mouthful. Achilles McCree, the former head of the London branch of JP Morgan Chase Bank's Chief Investment Office, agreed to pay a fine of just under 793,000 British pounds, or 1.15 million US dollars, to the Financial Conduct Authority for his alleged failure to be forthright with the Financial Services Authority, the FCA's predecessor, during the early stages of the so-called London whale trading incident in early 2012. This incident, which involved losses incurred by the Chief Investment Office's trading of credit default swaps and tranches, principally by Bruno Ixkill, ultimately cost the bank more than $6 billion US dollars in trading losses. According to the Financial Conduct Authority, from March 28, 2012 to April 29, 2012, Mr. McCree was the main contact at FSA at JP Morgan for the Chief Investment Office. Despite at least 2 formal meetings with FSA during this time, including one in person, Mr. McCree never advised FSA of the, quote, full extent of the difficulties, end of quote, the Chief Investment Office's CDS portfolio was experiencing, alleged FCA. As a result, charged the FCA, quote, Mr. McCree failed to deal with the authority in an open and cooperative way, end of quote, thus violating FCA requirements. After 3 years of discussions, the Commodity Futures Trading Commission and the European Commission agreed on a framework to recognize that the other continents' clearinghouses, sometimes known as CCPs, are subject to equivalent regulatory oversight. This is especially important for U.S. CCPs. Without such a determination, a U.S. clearinghouse could not be deemed a qualifying CCP under EU law, and European banks carrying positions there would be subject to penalty capital charges. As part of the agreement, U.S. clearinghouses seeking recognition in the EU will have to demonstrate compliance with certain new requirements that today is typically not required for all U.S. CCPs, if at all. Among other things, U.S. clearinghouses must evidence that, for clearing members, proprietary positions in exchange-traded derivatives, they collect initial margin sufficient to cover a 2-day liquidation process. Their initial margin models have measures to mitigate the likelihood that in times of market stress, initial margin requirements will increase from more stable times, i.e. pro-cyclicality, and they have sufficient resources to cover the default of the 2 members with the largest exposure to them. However, the requirement for U.S. clearinghouses to collect initial margin sufficient to cover a 2-day liquidation process would not apply to domestically traded agricultural derivatives. Under the framework, the CFTC will also make a determination that EU clearinghouses are subject to equivalent oversight. This will permit EU CCPs already registered with the CFTC as derivative clearing organizations, as well as those applying for registration, to meet certain CFTC requirements by complying with corresponding EU requirements. The European Commission formally proposed delaying for 1 year until January 3, 2018, the rollout date for the Markets and Financial Instruments Directive 2. The EC said the delay was necessary because, quote, neither competent authorities nor market participants would have the necessary systems ready by 3 January 2017, end of quote. MiFID 2 and its companion regulation, the Markets and Financial Instruments Regulation, are comprehensive measures that, once finally implemented, will greatly increase regulation of European financial markets by requiring the trading of certain financial and commodity instruments on regulated venues whenever appropriate, increasing obligations on certain algorithmic traders, and obligating speculative traders to limit the size of their net positions in commodity derivatives. The tumultuous life of MF Global Inc. ended last week when the U.S. federal judge overseeing the liquidation of the company formally closed the firm's estate and ended its liquidation proceeding. MF Global, formerly a Futures Commission merchant registered with the Commodity Futures Trading Commission and one of the largest futures brokers worldwide, filed for bankruptcy on October 31, 2011, after it could not locate over $1.5 billion in customer funds. Since then, the estate has made all of MF Global's customer claimants whole, returning $6.9 billion to cover 100% of allowed claims. An enforcement action filed by the CFTC in June 2013 against John Corzine, CEO of MF Global, and Edith O'Brien, assistant treasurer of the firm, claiming that the parent company of MF Global and the 2 individuals failed to segregate and misuse MF Global customer funds, is still pending. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, have a great week. I'm Gary DeWaal, and ciao.